Okay, Mr. Caldevilla, you're up.
May it please the court. Good morning, your honors. I'm Dave Caldevilla. With me in my office is my co-counsel and my client, Nikki Alvarez Souls, the clerk of the court for Pasco County. I'd like to reserve 5 minutes for rebuttal, please. This appeal involves issues of first impression concerning the county's obligation to fund expenses incurred by a clerk's office for two types of court-related functions. The first type is expenses incurred to operate and maintain an existing multi-agency criminal justice information system, which we'll refer to as the CJIS system. And the second type is expenses incurred to meet local requirements. Under Article 5,
Am I correct that the county has now agreed to fund this system, thereby leaving the only issue before the court as to count one, the ability to phase it in over, phase payment in over 3 years? Has that now been determined?
I sure would like to say that, but no, I don't believe that's correct, Judge. Let me say this: at the Board of County Commission, the county attorney said that the clerk is right about this. We're responsible for CJIS. The only issue is whether or not we can phase this in or not. They also agreed all over the place to the amount of money that the clerk budgeted for this. That was never disputed. But when we get into trial in this case, not trial, but we get into this case, the county seems to back off of the position of whether or not they're even responsible to pay any of the CJIS expense, and I will get into that.
That's where I'm kind of confused, because I did read the trial transcript, and it seemed like the county was of the position that they had the option to either pay or not pay, but in order to help out the clerk, they were agreeing to pay. It's hard to make it all add up.
I agree with you, Judge. They seem to be playing it both ways, and I'll get more into that today. So one thing I'd like to point out at the outset is Article 5, Section 14B of the Florida Constitution says the clerk is only allowed to use court-related revenues to pay for performing court-related functions as required by general law. And under Sections 28.35 and 28.36, the clerk is prohibited from using court-related revenues to pay for any expenses associated with the CJIS or for local requirements or any other enhanced levels of service. Now, let me repeat that. The clerk's office is prohibited from making the types of expenditures at issue in this case. On top of that, Section 29.012 says the legislature declines to fund the clerk's court-related functions. So that means someone else is required to pay these expenses, and we submit that someone else is the county. With that backdrop in place, we contend the trial court erroneously denied the clerk's motion for partial summary judgment on count 1 and erroneously granted the county's motions for summary judgment on all our counts. In count 1, the clerk seeks a declaration that the county is required by Article 5, Section 14C of the Constitution and Section 29.0081H of the Florida statutes to fund the CJIS system, and that the county is not allowed to phase in that funding obligation over multiple years. As I mentioned before, the county attorney himself advised the county commission at a public meeting that the county is responsible for funding the CJIS. The county also repeatedly agreed to fund the full $789,000 amount of the CJIS expense, but the county merely contended that it could phase that in over 3 years. Well, Article 5, Section 14 says counties shall be required to fund the cost of the existing multi-agency criminal justice system. Section 14C does not impose any funding obligations on the clerk, nor does it authorize any county to phase in or otherwise delay payment. The only phase in that was authorized is described in Article 12, Section 25 of the Florida Constitution, but it doesn't apply to counties. According to Article 12, Section 25, any phase-in schedule had to be established by general law. And regardless of any phase-in, the amendments to Article 5, Section 14, had to be fully effectuated by July 1st, 2004. To be certain, no general law was ever enacted that established a phase-in schedule for counties to meet their CJIS funding obligations. And the July 1st, 2004 deadline expired 19 years ago. So any ability to phase in this obligation has clearly lapsed. Now, even though the county attorney advised the county commission that the county is responsible for the CJIS expense, during the lawsuit, the county's backed down off of that position and now contends they're only responsible if it's a quote, an existing CJIS as it stood back in 1998 when Article 5.
Which is what the trial court found.
Right, which is what the trial court found. The trial court agreed. So that brings us to section 29.0081H, which is the definition, and it implements that constitutional provision and defines the term existing multi-agency criminal justice system. I don't have time to read it word for word today, but that definition uses very broad terminology, such as includes but is not limited to upgrades to assure continued information sharing and reporting of information to the state, and that the counties are also required to provide additional services, hardware, and software as needed. Regardless of the word existing in the defined term itself, case law tells us that statutory definitions are what controls, and that definition does not link the CJIS to any particular date or event. The word upgrade, as used in that definition, is not defined by Chapter 29, and absent a statutory definition, the court's required to construe the words in a statute in accordance with their common and ordinary meaning as defined by a dictionary. The dictionary definition for the word upgrade is to replace something. And in particular, with respect to computer equipment, they say it's to replace computer equipment with a more useful version or alternative. That's from the Merriam-Webster's dictionary. And we cited many, many dictionary definitions. The word current that's used in that definition, that means at the present time and the most recent. These are well-settled dictionary definitions of these words. Now, section 29.008.1H, it was enacted in 2000. And 7 years later, in 2007, the legislature expanded that definition to include a computer system needed by guardian ad litem's office. So if this was a computer system that was supposed to be in effect in 1999, we're talking about 1998, why is the legislature in 2007 expanding the definition to include computer systems for guardian ad litem offices? It can't work that way. And the constitutional provision 14B tells the legislature to define court-related services by general law. And so that's what they've done here. They've defined this court-related service by general law. And the plain text of that statute does not anchor the county's funding obligations to this obsolete computer system that was in place in 1998 when this Article 5, Section 14 was enacted, or any other historical date or event. The legislature, when they want to avoid the normal effects of the statutory reenactment process and want to fix a statutory requirement to a particular date, the legislature knows how to do that. At pages 46 of our initial brief, we cited several examples of statutes that are anchored to a particular date. And we don't really have to go that far because section 29008 itself in subsection 1A2 talks about equipment and furnishings under this paragraph in existence and owned by the counties on July 1st, 2005 shall be transferred to the state at no charge. It's anchored to a date. The existing computer systems is not anchored to a date. Existing radio systems also refers to the radio systems that were operational and under contract at the time of revision 7, 1998 to Article 5. There's no such provision in the existing CJIS definition. So it's just not there. The plain language of the statute, which we're bound by, nobody's challenged the validity of that statute. I want to point that out. Nobody's challenged the validity of that statute. You have to comply with it. Likewise, if you go to Article 5, Section 14, it's not anchored to the effective date of revision 7 or any other particular date. In our reply brief, we cite to Article 5, Section 20. There's a provision in there that abolishes certain judicial offices as of the effective date of this article. You don't see that type of language with respect to the provision 14C. So the trial court's decision essentially authorizes the county to shift its constitutional statutory funding obligations to the clerk and turn the clerk into the de facto lender and subsidizer of the county. And this result is particularly egregious because Section 28.35 and 36 prohibit the clerk from funding these expenses. In count 2, we're seeking a declaration that the clerk's duplication of court-related functions at the courthouse annex is a local requirement. Again, under Section 2835, the clerk is prohibited from paying for local requirements as well as enhanced levels of services. Clerks are prohibited from paying these types of expenses.
Courthouse annex is functioning essentially as the main courthouse. They're doing the same tasks, aren't they?
They're duplicating services, Judge. Yes, they are. So according to Article 5, Section 14C, counties must pay the expenses of state court systems to meet local requirements as determined by general law. In this case, we have a general law that explains how to determine if something's a local requirement or not. That general law is Section 29008. And under subsection 2A, local requirements include resources required of a local jurisdiction as a result of special factors or circumstances. Subsection 2A also gives us several ways to determine whether local requirements exist. One way is when there's an express statutory directive based on the factors provided in subsection 2B. And there's a list of 5 of those factors, but they include, but are not limited to, geographic factors and the number and locations of court facilities. When the legislature enacted this statute, they obviously knew that some counties have multiple courthouses. Otherwise, they wouldn't have listed the number and location of court facilities as one of the factors that could be considered an indicator of a local requirement.
Let me see if I can just try to put my arms around the issues that are before us. In the judge's order, she says the county may provide funding for the subsequently acquired multi-agency CJIS system, but its mandatory obligation extends only to the current system. The current system, as defined in that passage, has now been replaced, hasn't it?
Well, no, the current
system that was in effect at that time.
Back in 1998, that system that was in place then is the hardware is not there, but the criminal justice information that was on that system has been migrated to the upgraded system.
Your position that it's been the system has been upgraded.
Yes.
New
yes,
hardware Judge. And I guess perhaps new software as well.
Right. And yes.
And an upgrade is required to be funded by the county. That's what
we contend that certainly under the statute it is. The constitutional provision is silent, but the Constitution also says that court-related functions are going to be required by general law. And so this is a general law that defines existing CJIS systems, and it says it concludes upgrades, and for the purpose of continuing to ensure the exchange of its information to state agencies. So where does it say that the county can just unplug the system, or if it had a system in 1998, it can just throw it out the window and walk away from it, and it no longer has that obligation? Certainly, the county is required to have a CJIS system. They made a decision to upgrade it. Certainly, they have the continuing obligation, according to the definition, to maintain and operate that system. And again, the clerk is prohibited from paying this, and the clerk's office has become the de facto lender, or really subsidizer, of the county. But getting back, if I could, I want to spend some time on the local requirements, because that's another important issue. It's local requirements as determined by general law. We have a general law. The general law tells us how to do it. The legislature authorizes counties to build an auxiliary courthouse by special act. You're not going to find general laws that authorize a particular county to erect an extra courthouse outside the county seat. The legislature does that by special act.
You are at 5 minutes, Mr. Caldevilla, so proceed as you
All
wish.
right. Thank you. I'm going to take a couple more minutes, Judge. But we contend that the general law requirement is satisfied because 29008 is a general law. That statute says it has that a local requirement can be imposed by an express statutory directive based on these factual factors. We think that express statutory directive can be a special law, and we think that the legislature recognized that in that subsection 2B4 when it said multiple courthouses. The only way you can have a multiple courthouse, more than one courthouse, is in a special act by the legislature. So in Chapter 59, 1715, it's a special act. The legislature authorized the county to build this annex at the opposite end of the county to provide services to the residents out there. And they said that's a county purpose, and it's going to be county funds are going to be expended for that purpose. In 1963, another special act said the clerk shall provide services at that annex. So
I'm not sure where I got this from, but I have written down that the clerk seeks a declaration that the courthouse annex is entitled to payments as a local requirement. But that would, an example of a local requirement would be a legal aid program, an alternative sanctions coordinator, some sort of peripheral spinoff from the main courthouse. And the argument that I read somewhere in all this was that since the two courthouses are doing essentially the same thing, they're both fully functioning courthouses with prosecutors and defense lawyers and judges split up. I don't know if it's evenly, but they're distributed across the two, that this would not meet the definition of a local requirement. This is a courthouse. It's not a branch or a department that's affiliated with the main courthouse.
Judge Northcutt, can I have some time to answer that question, please?
Yes, you may.
All right. Judge Black, so this is a duplicate courthouse. It is an annex. By law,
The county seat remains in Dade City, correct?
right. The main courthouse is required by general law. Every county is required to build their courthouse in their county seat. Some counties are authorized by special act to build an extra courthouse, an annex courthouse, someplace else other than the county seat. That's what we have in this situation. And when it happened, the county agreed that it was going to expend county funds to run that operation. The clerk's office has to provide duplicate services to go out there, enhanced services, if you will, more services than would normally be required if they just had everybody at the same courthouse. They're going to have, for many positions, double, 2 people to run what would normally be 1 position. And there's no evidence. So let me wrap up because I would like some rebuttal time. But I want to point out all of the evidence in this case is in our favor. We presented the evidence on these factors. There is no evidence presented by the county at all with respect to any of these factors. And that you cannot support a summary judgment without any evidence. And that's what we have here. And Judge Northcutt, in the Mack versus Hyundai Motors case, which is a decision you wrote last year, this was a summary judgment by the same trial judge where she failed to properly interpret the plain text of the statute and failed to recognize that there were disputed issues of fact. We have the same thing here. So I'll reserve any more time that I have for.
Okay, I will accounting for your time to respond to Judge Black. I'll let you have 2 minutes for rebuttal.
Thank you, Judge. Appreciate that.
Mr. Stewart, it's your turn.
You're muted.
You're muted, Mr. Stewart.
Muted.
You're muted. There you go.
Thank you. Let me address Judge Black's original question to council. The county's position is that at the time that the budget was submitted in fiscal year 21-22 from the clerk to the Board of County Commissioners. At that particular time, the county had questions, and that's reflected in the record. They did not agree to fund the entire amount in a single year, but indicated they would fund it over 3 separate budget cycles. So the primary question is, does the Board of County Commissioners, in the consideration of the clerk's budget, have the ability to modify, address, alter the clerk's budget, including phasing?
Does that,
They do.
does that turn at all, Mr. Stewart, on the question of whether the county is required to fund this system? I mean, for instance, if it seems to me that if you're not required, the fact that you're willing to do it voluntarily weighs in favor of you phasing that in. But the question is if you are required to fund this, can you phase it in?
Well, I believe you can. And I think that
Even if Mr. Caldavia's position that you are required to fund it is correct? Because
yes,
those,
under
those
that
questions can
approach.
be divided, but they're connected.
Yes, I agree. I understand. And my view on that is that the obligation to fund a particular expenditure, whether it's the CJIS system, whether it's patrol cars, whether it's jail personnel, that the Board of County Commissioners has a finite amount of funding. And it must, in fact, juggle from a variety of different entities. And so in the budgetary process, and I'll just deal with the clerk's position at this point, the clerk's budget is bifurcated. There is a court-funded piece that goes through the corporation created by statute, and the state funds the judicial functions or the court functions. The county functions go through the Board of County Commissioners, and that's really what we're talking about here. And in this particular case, the statutory provision that governs the consideration of the clerk's budget by the county has this particular language. The Board of County Commissioners may require such changes to be made as it deems necessary. And that is in the consideration of the budget. And that's section 129.03 parent 3.
Let me ask you this. Let me ask you, and I understand where you're going there. And I think that we have competing rights and responsibilities here between the parties that we have to try to figure out. But let's assume that this system is required to exist, or everyone has agreed it should exist. And I think there would be a unanimous agreement there. And the county commission wants to phase in its financial support of it. Who pays for it in the meantime? If
Well,
Mr.
I think
it's
that
correct that the clerk cannot.
I think the concept is that is a system that would be funded through the state. I mean, we're dealing with 2 funding sources for 1 constitutional officer. And the intent, I believe, of the constitutional amendment and the statutory implementation is that the county continue to operate that system as it existed once the constitutional amendment was approved. However, and all due respect to council, the definition of CJIS talks in terms of upgrades to the current equipment. It nowhere says that it talks about replacement systems. And so my reading of the Constitution and the statute is that if the county doesn't have that obligation, it is then a state obligation. Now, what ends up happening in counties around the state is that they work together with their constitutional officers. They sit there and they say, well, we're going to help you with this funding. The state is a limited revenue source too. And so they contribute money to this. But merely because the county has the obligation under council's argument doesn't necessarily mean that it must be spent entirely and completely in a single budget year. And the county has that discretion to utilize its limited resources to meet all the needs, not just one at one time in 1 year. There's nothing in Florida statutes that says the county's obligations to the CJIS system goes to first in line. That's not contained. The county, under its budgetary authority, has that discretion and needs to have that discretion. Now, the clerk takes the position that the county has no ability to alter the budgetary process of the clerks and must just approve it. However, every constitutional officer has statutory provisions which grant to the Board of County Commissioners broad discretion to address their budgetary needs. The sheriff under section 30.49, supervisor of elections under 129.201. Each of those give broad authority to the Board of County Commissioners to provide for those basic needs. Now, I do need to kind of do one clarifying point. The budgetary request that we're talking about here was for a variety of technological needs. And the clerk has characterized them broadly as all sieges. That's not really clear on the record whether that's the case. But in terms of whether the county has the ability to phase what the clerk did submit, absolutely they do. And I would, first of all, the council references Article 12, Section 25. Well, that's a transition provision that dealt when the transition of partially funded state court system by counties became entirely the state. And that gave the 3-year period. Nowhere in that provision is there a limitation on the county's budget authority in any other context. I would also point out that even though we're here arguing today, when the clerk submitted her budget request for 21-22 to the Board of County Commissioners, she submitted a transmittal letter. And in that particular letter, she herself proposed to the Board of County Commissioners to phase the expenditures. And the language she has is, understanding the county has many commitments to the community, I remain open to discussing a phased approach prior to CFY 2021-2022 final budget approval. She herself recognized that phasing was a viable and available tool for the management of the budget. And it is a factor that has been used repeatedly in Pasco County for the sheriff, for the supervisor of elections. There are requirements under statutes that the county has to fund those expenditures, but that did not create a limitation on how that expenditure is managed. Now,
Is it accurate to say that going forward, the county is of the position that they can either pay for this or not pay for this at their discretion? And that if they choose to pay for it, then they are entitled to phase it in over 3 or however many years they select? Is that an accurate statement?
well, I think
the way I
that,
read the court's order, the court says
yeah, I mean, I
they're not
think that
required
the
to pay,
county,
but they can if they want to, in so many words. And the court also gave you latitude for this phase in. And I guess when we're done here, you're going to ask us to affirm those aspects of the court's order. Mr. Calavia is making his pitch as to why that's inappropriate. I'm just trying to figure out, if we write this, what's it going to write like issues wise?
well, I think that that's the, I mean, that is the county's position, that the obligation itself for the CJIS system alone, those technological needs, that is no longer replaced. It's not been an upgrade to the system. That entire system has been completely replaced. But what there is an issue that I think has to be recognized.
Which
Let me
then
add-
ends-
I'm sorry, go ahead. Go ahead, Judge Black.
that ends the clerk's out, that ends the county's obligation. Because if the system is all new, then the county no longer is obliged to fund it. They may, but they're not required to.
The CJIS piece of it, under the reading of the Constitution and the statute, is that they do not have the obligation as a continuing forever. However, the reality is that same system, which provides the CJIS system, also provides computer support for county functions. So there is a county need they would have to fund. So it's kind of like splitting the baby a little bit in terms of the cost.
I mean, as a practical matter, it would seem that the county would continue to fund this.
I have no reason to believe the county is not going to fund it, but
Which gets us back to the county, whether the county has the authority to declare what the payment periods will look like.
Well, I think absolutely in the county's management of its budget, it has to have the ability to look at the needs of not only the clerk, but the sheriff, the supervisor, county departments, all of those. And there is a limited pot of money. And so that has to be addressed and spread over a lot of needs. And that's
How
all
would
we're
you-
talking about in terms of phasing.
Mr.
How do you
Stewart,
go-
looking at the statute 28.008, whatever H1H, and it does discuss and under the definition of existing multi-agency criminal justice information system, it said includes upgrade and maintenance of the current equipment, maintenance and upgrades of supporting technology infrastructure and associated staffs, and services and expenses to assure continued information sharing and reporting of information. Couldn't that include the replacement or upgrade to hardware and software? And as I say, if they're running this on a Windows 286, it doesn't work anymore. I mean, it just has to be physically upgraded. And couldn't the services and expenses to assure continuing information sharing be included in that upgrade?
Well, and that is exactly what happened.
You're kind of cutting out. I don't hear you very well.
Maybe what happened when it replaced the system. The county paid for the system in 2009 to 2019, and it was implemented. That's the CJIS system, but the entire system had to be replaced, and the county did that and paid for it.
So the question that I'm asking isn't that the county did, but isn't the county required to within within that definition under 28?
Well, I think that I'm not sure I would want to characterize that particular language as always dealing with the issue of the complete replacement. I mean, it does talk about trying to make sure the system is continuing to communicate. And I think those type of improvements, now what that would entail, I'm not sure I can answer that in its totality.
Well, I mean, I would suggest that it would vary depending on what we're talking about. Like, do you need a new DSL line or whatever they use now? Do you need a new process or whatever? But it would seem to me that that's sort of the catch-all phrase in that requirement, correct?
Well, I mean, I think that it's contemplating improvements to keep the system functioning.
Okay.
So now, whether that goes to the point of an entire new replacement system, I think you'd have to look at the individual circumstances. Let me address real quickly.
But you would acknowledge, though, that the county's obligation goes beyond just the original equipment or just the original system as it existed when the constitutional provision was enacted.
I would acknowledge that in terms of the contemplation is that as to the system that was in a place at the constitutional amendment, that there are changes and upgrades to that current equipment. What we are talking about, I think in this case, is if you have a wholesale replacement of the system itself, is that maintaining the existing system, or is that an expenditure that is beyond the existing system? And that is what the Constitution required, and that is what the implementing statute.
Well, I don't know. I'm reading the implementing statute right now, and it does seem to suggest services and expenses to assure continued information sharing. And so you're suggesting that if that is a complete replacement of the equipment, that doesn't obligate the county, but if it's some other improvement or upgrade, it does, correct? Just trying to figure out where you guys stand on what your obligation.
The telling point on that definition is nowhere does it talk about replacement. So when you cite that particular language, The question is, does that extend all the way to a complete replacement? I'm not so sure that does. I think
Well,
that
it doesn't have any limiting language applicable to that phrase.
it doesn't have anything, it doesn't indicate that language is not limited. But like I say, the definition as a whole is dealing with the current equipment.
Okay.
Now, let me talk quickly about the local requirement. In order to have a local requirement, there's two processes. The only issue in this case is whether the legislature has adopted a local act, a general law provision, which in fact express statutorily directives that this constitutes a local requirement. Now, we submit, and that the best indicator as to what that means and what is intended is what the legislature has done in the past. And this is an issue that Judge Black raised. In Florida statutes, that same implementing provision, 29.008 paren 3, the legislature has in fact created two local requirements. Both of those were adopted by general law, which the Constitution requires, and the express statutory directive is an indication that that in fact is going to be a local requirement. So you do not have a situation where you have a local requirement created by inference. And the best indicator as to that is the interpretation of that provision is the language of adopted by the legislature that says the following shall be considered a local requirement to subparagraph 2A1, which is the legislative enacted provision. That's 29.008 paren 3. When the statutory provision is talking about an express statutory directive, it's talking about this shall constitute a local requirement. And that's what we're talking about. In this case, the clerk is relying on two special acts that were adopted more than 35 years prior to the constitutional amendment. It's chapter 59, 1715, chapter 63, 1761. Neither of those contemplate being a local requirement because the requirement did not even exist at the time. Nor is there any language in either the current statute, 29008, or the special acts that would indicate that the legislature intended to grandfather in those provisions. Absolutely none. So, in fact, it's even worse because at the time that those special acts were adopted, the funding mechanism for the state court system was completely flipped on its head. Counties funded trial courts, state funded appellate courts. And to sit there and suggest that now those special acts, which were adopted back then prior to the 1968 Home Rule Constitution, is ludicrous because they could not possibly have been contemplated to be a reversal of what the citizens voted for when they adopted revision number 7 in 1998 for the funding of the state court system.
Well, with regard to your statutory interpretation there, though, I mean, isn't the definition of a local requirement in 2A or 2B rather, it says factors and circumstances resulting in the establishment of a local requirement include but are not limited to, and one of them is the number and location of court facilities. Correct. And so under 3, you know, if the legislature is laying out these factors, why in the world would it, if it was just going to limit local requirements to what it expressly designates as such?
Well, and I think the question Judge Black raised in terms of local requirements as adopted by the legislature and what they constitute. And those particular provisions are limited. General operational costs of the court system in a courthouse annex are general expenses. They are not special needs, special programs which the definition of local requirement contemplates. And I think it's important to recognize that one of the reasons why the revision number 7 was proposed by the Constitutional Revision Commission is the disparity that arose between counties in terms of funding the court system. So anytime, and the argument of the clerk is that a special act which only deals with one county can constitute a local requirement, that is contrary to what was attempted to be addressed by revision number 7 in the constitutional amendment. We were trying to come up with a uniform system that was not impacted by the specific limitations and funding needs of each individual county. To utilize a special act that only applies to one county is contrary to what was intended by the constitutional revision, constitutional provision. I think
Mr.
that
Stewart, we have gone over your time.
I'm sorry
Give you
about
another couple of
that.
minutes because I'm giving Mr. Caldevi a little more for rebuttal.
We would ask that the court affirm the judgment that has been entered by the trial court in this matter. Thank you.
Okay. Thank you much. Mr. Caldevi, can you do 2 minutes? I know you
I'll do
can.
my best, Judge Mark. Thank you
Okay.
so much for the 2 minutes. May it please the court. With all due respect to opposing counsel's contention that our arguments are ludicrous, we are basing our arguments on the plain language of the Florida Constitution and Section 29008 and the other statutes that we've cited. And again, let me remind the court, we're prohibited. The clerk's office is prohibited from funding these things. If in the state under 29012 has declined any responsibility to fund these items. So somebody's got to pay for it. Now, with respect to the local requirements, because I think that the CJIS has been addressed enough, but Judge Black and Judge Northcutt, the provisions in subsection 3 of 29008, those are examples of 2 types of local requirements that the legislature did decide to designate and identify specifically. Local aid and I forget the other one off the top of my head, but right. But if that's the only way you can have a local requirement, then Judge Northcutt, as you were suggesting, then that makes subsection 2A1 and the factors in 2AB completely superfluous. That those are the only ways you can if you can only have a local requirement that's identified in subsection 3, then the rest of the statute's meaningless. And when we know we're not allowed to construe statutes in that manner. Special acts.
In that regard, though,
go back
in that regard, and now I'm using up your rebuttal time, but in the same statute under C, I guess, says local requirements must be determined by a method that includes like the chief judge of the circuit certifying the need to the county commissioners and so forth.
Right.
Has that happened in this case?
Right. That's a separate one, Judge. It says local requirements under subsection 2A2. We're under 2A1. 2A1 says go to subsection 2B, which is the factors. So no, we agree that there's no order of the circuit court. I would like to just touch base on the council's argument that, well, all this happened in 1959 and 1963. There was no such thing as a local requirement back then. Well, certainly there was no, that term hadn't been coined back then. But when the legislature enacts a statute, they do so with the full, we're required to presume that they did so with the knowledge of these special acts. And in 29008, 2B, subsection 4, it says multiple courthouses. Well, the only way you can have multiple courthouses is through a special act. So I know I'm out of my time.
Yeah, you need to wrap
There's a
up.
lot going on. And so we rely on our
Moving
briefs,
parts
but,
here,
we
for sure.
respectfully request the court to reverse and reinstate our counts and remand for further proceedings. Thank you so much.
Thank you, Mr. Caldevi. I cannot express to you how much I appreciate you bringing this interesting case.
You're welcome. I was court excited and interested in what's going on.
Yes. In order to leave our virtual courtroom, you need to click the button on your Zoom screen that says leave, and then you'll leave. Thank you.